All right, shalom, shalom, shalom. Once again, you're not under the sounds of the voice of your good brother Taza Dark. And this is your house work. For the record, this is not legal advice. I do not offer legal advice. If you need legal advice, seek yourself a competent counsel and then please be advised. Everything I'm about to give you is strictly for educational, informational, and entertainment purposes only. Not to be taken as legal advice. So I want to welcome you all out to my next up and coming webinar, which is actually going to take place this weekend, April the 10th and April the 11th from 12 noon to 6 p.m. both days. You could click the link in the room or you could click the link below this video to get registered. Be sure to attend this webinar. Why would you want to attend this webinar? Well, if you happen to be one of those people that's drowning in a sea of debt, you want to attend this webinar. If you happen to be one of those people that has a financial noose around your neck with the Biden administration in office, inflation soaring, gas prices soaring, and your purse, it seems though as it's almost on empty. So that is one of the reasons of many why you want to attend this webinar. You will learn how Taza Doc effectively discharge all of his alleged debt, repaired his commercial situations, and came out on top. So you definitely want to attend this webinar. Once again, that's going to be April the 10th and the 11th from 12 noon to 6 p.m. both days. You could go ahead and click the registration link within this comment section of this video or below the video after the video's done to go ahead and get registered. Now, you may have a student loan. You may have an auto loan. You may have a debt of foreclosure, or you may have, once you had good credit and you got those credit cards and you didn't have any control, so they got beyond your control, and now you're drowning in the sea of credit card debt. Attend this webinar. Learn how you could get back on your feet and stand as a man effectively. Now, what exactly is accepted for value? Accepted for value is a concept that you may often hear many people using, but very few comprehend it because it is often misunderstood. So I'm gonna take a few minutes to attempt to explain this to you. Right now, accepted for value is a commercial remedy, and you, my brother and sister, are more than likely like the average American citizen drowning in a sea of commerce. If you want immediate help with that, please attend this webinar Saturday and Sunday from 12 noon to 6 p.m. The registration fee is only $100 for something that's going to save you thousands. And by the way, please visit my website, www.truedisciplesofchrist.org, and order my books, DVDs, and flash drives of previous webinars. Now, back to the accepted for value. Accepted for value is a commercial remedy. A remedy is a commercial right, family, that is obtained through an instrument, and such instruments include tax bills, violation tickets, etc., etc. Accepted for value is a qualified endorsement. An endorsement is a modified signature, by the way. So an accepted for value is a qualified endorsement on an instrument. A blank endorsement is simply your signature or total non-acceptance. A blank endorsement waives remedies that are made available through the instrument by waiving the defects in the instrument. Do you understand? Do you understand? Now, what is acceptance? See, to properly comprehend what acceptance for value is, one must first overcome aphasia. It's called aphasia. And you also gotta be totally undaunted, and one must never engage in polemics. So we have to overcome this aphasia by re-comprehending the true meaning of words. So get yourself a Black Lewis dictionary and get Tyler Dockshaw's book, and then get you a good book on contract law. So Black Lewis Fourth is my favorite. In Black Lewis Fourth, acceptance is stated as thus: acceptance, an agreement either by express act or implication from conduct to the terms of an offer so that a binding contract is formed. If an acceptance modifies the term or adds new ones, it generally operates as a counteroffer. That's Black Lewis 7. Black Lewis 4 states, the taking and receiving of anything in good part, and as it were a tacit agreement to a preceding act, which might have been defeated or avoided if such acceptance have not been made. Now, what does that all mean in layman term? As you come in the room, give a thumbs up. I know it's early, especially if you're in Cali. It's only 5 a.m. in the morning over here, getting pretty close to 6, but you know me, I'll sleep when I die. So, according to what I just read from Black Lewis, not something that Tyler Doc made up. Again, go ahead and give a thumbs up as you enter the room. And if you're just entering the room, be sure to click the link below this video and go ahead and register for the webinar that's actually going to be coming up this Saturday and Sunday, April the 10th and April the 11th from 12 noon to 6 p.m. Register now, get out of debt. So, if an instrument is issued based on a pre-existing agreement or a contract, it does not have to be issued for value. See, the issuer's defense are in the contract, if you could comprehend. See, if the agreement of the transferee being the person who receives the instrument, for example, the U.S. citizen receiving a violation ticket, so-called traffic citation, is not preferred to the satisfaction of the transferor, he could back up his claim with that contract. So if there is no pre-existing contract, the instrument must be issued for value. So issue for value is the same thing as issue to get value. Do you understand? Do you understand? Thumbs up as you come in the room. So the instrument has no value when it is issued. It is seeking it. Do you understand? It is seeking value. When they issue you the instrument has no value. See, it is seeking a person to accept his offer unconditionally and thereby waiving all remedies made available. Do you understand what I'm saying? See, when you receive a tax bill, right? A traffic ticket, right? A penal action, right? Indictments, right? The presumed basis for issuing the instrument was the violation of a United States code. So if you have no contract or promise given to act under those statutes, brothers and sisters, there is no obligation to pay. If a person gives this instrument a qualified endorsement, Accepted for value, he is literally turning the instrument into the payment. Big facts. Thumbs up as you come in the room. Thumbs up as you come in the room. Now, the transferee gains a security interest in the instrument and becomes the holder in due course. The liability stays with the issuer instead of being transferred to you. So, in that position, you can enforce the instrument on the issuer. He becomes the transferee. Let's have a look at UCC 1-201. UCC 1-201, general definition. Value, except as otherwise provided with respect to negotiable instruments and bank collections, section 3-303, 4-211, a person gives value for rights if he queries them. A, in return for a binding commitment to extend credit or for the extension of immediate available credit, whether or not drawn upon and whether or not a chargeback is provided for in the event of difficulties in collections, or B, a security for in total or partial satisfaction of a pre-existing claim, or C, by accepting delivery pursuant to pre-existing contracts for purchase, or generally in return for a consideration sufficient to support a simple contract. So, UCC 1-201 says that if a person gives value to get rights, right? If one person is given value, that other person is asked to give rights in exchange. So an implied contract or promise can't really be enforced. Do you understand? Do you understand? An instrument that's demanding performance on its generally an offer to create a new contract. This is what's happening. If you accept that by just signing it, you are accepting this new contract. You now have the liability and you got to pay. And it's really that simple, folks. See, when the issuer issues an instrument for value, he is risking the liability on it. If you call his bluff, family, he could be made to pay you. If the issuer of an instrument for value does not counter your counter offer, you're in a great position. Most of you just don't comprehend this. See, commerce is set up to be unfair. It is based on the law merchant. It is in favor of creditors. That's why I told you got to be a creditor. Stop being a debtor. It is set up in favor of creditors seeking collection. And in most situations, the only thing that must be determined is who is the creditor and who is the debtor. And once that is known, once you sign that ticket with a naked acceptance, all other facts generally become irrelevant. Do you understand? Do you understand? Thumbs up as you come in the room. Thumbs up as you come in the room. See, acceptance for value establishes you as a creditor. Stop listening to these damn briefcases, man. I'm giving you right knowledge for real. Once again, if you're just coming into the room, go ahead and click the link below and get registered for this up-and-coming webinar this weekend, this Saturday and Sunday from 12 noon to 6 p.m. on both days. Going to show you how Tyler Doc has actually cleared his credit and soared with discharging every single debt that he has and is living a much better life than he previously was living. I know you want to live that life. I know everyone on this call want to do better. There's a reason that you're coming here. And let's keep that in mind. So, looking at UCC 1-201 subsection A, right? Here are some examples of exchange of value for rights, excluding UCC 3-303, 4-210, 4-211. A person gives value for rights if he acquires them. A, in return for a binding commitment to external credit or for extensions of immediately available credit, whether not drawn upon and whether or not charge back is provided for in the event of difficulties in collections. So a person being a borrower gives value, that's right, to foreclose access on the bank's books for rights, that's use of public credit, if he gets those rights in return for a commitment to extended credit, which is a promissory note. So a person, which is also the lender, aka the creditor, gives value. That means he uses public credit for rights to foreclose. If he get those rights in return for a commitment to extend public credit to a borrower, which is aka the debtor. See, that's in the public side. A person, the borrower, gives value, the private man's credit via his signature on a note. That is your value. What is my tender payment? My pen, my signature on a note. For rights, that's the use of currency. If he gets those rights in return for a commitment to extend credit, his private credit to the lender. A person, a lender, aka a debtor, gives value liability on its books for rights, the use of the man's private credit, if he gets those rights in return for his commitment to extend public credit to the debtor. This is from the private to the public. You see what I'm saying? If you do not comprehend this, consider how money is created. To those of you that still don't get it. To those of you that still don't get it, all money is wealth. I see you up already, General Yashibin. Shalom. All money is wealth, not money. It is credit, which basically means all money is debt. Money is created off of the man's promise to pay the money back. That's how it's created. The money isn't created out of nowhere. It needs someone to create the credit off of. You understand? It needs the energy of a man or a womb man to sign before it creates money. Therefore, the signature has value. And this is true because the bank can't lend its own credit. That's why they call it extensions. It is extending another person's credit to a third party. It isn't a loan, folks. It is an extension of a previous process. The credit comes from the man who's in the private to the bank who's in the public and back to the U.S. citizen. The man represents the borrower in the public. See, the man can enter the public because he is a physical being. He needs a U.S. citizen to represent him there. You understand? The man can't enter the public because he is a physical being. So he needs a U.S. citizen to represent him there, who is your debtor, your straw man. The U.S. citizen needs him, the man, to sign the instrument. So the man must represent the citizen and supply his energy. His energy is the signing of the instrument. The man will actually be presumed to be the accommodation party and not receive any rights unless he negotiates the terms to be advantageous to him. Do you understand? Do you understand? If he lets his signature be used without making new terms, he won't get any rights in return for the value he gave, which was his extension of credit. See, instruments issued for value demands that have no written contracts to back them up are nothing but requests for a man's credit. That's all they are. That is all they are. They are credit applications. Do you understand? They need you for money. Joey needs you for money. If he signs it correctly, he becomes the creditor. So now when we look at this, when dealing with the public person, aka your straw man, a person, The United States give value birth certificates, certified security U.S. citizens for rights to use U.S. citizens as a surety in return for his commitment to extend public credit and benefit to the U.S. citizen. A person, U.S. citizen, gives value pledged to the U.S. for rights to operate in commerce in the United States. He gets those rights in return for his commitment to extend public credit, to be a surety to the U.S. public. That's public to public right there. A person, the United States, give value birth certificate, certified security U.S. citizenship for rights, get use private credit if he gets those rights in return for his commitment to extend public credit distribution from his trust to the man through the U.S. citizen. A person, U.S. citizen, gives value man private credit to the U.S. for rights to operate in commerce in the U.S. if he gets those rights in return for his commitment to extend private credit of the man who represents the U.S. citizen to the U.S. See, there is more to these examples, folks. But I would suggest getting my books, Commercial Warfare, getting the plug, getting Liberate the Oppressed, and getting my webinars to clearly comprehend this stuff. When you accept for value, you are using your position as a beneficiary of a trust created by the Constitution and one in 1933, created by President Roosevelt. The reason you have this right is because of the constitutional oath the President Joe Biden took in Article 2. See, the black robes judges the 5 USC 3331 oath of office. An oath of office is different than an oath. And I'll let you get into all that. But my point is, as long as there is an officer with an oath required by the Constitution, the people will still have a trustee for the trust on which they are beneficiaries. The people are an antecedent claim for a pre-existing contract, which is based on constitutional guarantees. Dr. Doc, what do you mean by the word antecedent? It is called aphasia. Antecedent, go and look it up. That means some previous claim. So the birth certificate, folks, is a remedy. It represents the antecedent claim you have against the United States and is evidence of a pre-existing contract. It is the birth certificate. It represents the prepaid account you have available to you for settlement, and closure. Acceptance. Once again, acceptance. Acceptance by silence, acceptance of an offer, not by explicit words, but though the lack of an offer response in circumstances in which the relationship between the offerer and the offeree justifies both the offerer's expectations of a reply and the offerer's reasonable conclusion. The lack of one signals acceptance. Ordinarily, silence does not give rise to acceptance of an offer, but his exception arises when the offerer has a duty to speak. That's Black Wars, the 7th edition. So the bottom line, folks, if you act like a U.S. citizen in your communication, there is no obligation to respond. If you act like one of those beneficiaries on the trust created by the Constitution and Franklin Delano Roosevelt, then they do have to respond. And their silence is acceptance, it's acquiescence. Your communication should give the term, the agreement to another party, who must have a delegation of authority that represents the United States. The president combined the United States and its agents who could do it on his behalf, which are the hearts of the 3 executive departments: Homeland Security, Treasury, and Justice. The Secretary of the Treasury is the banker for the U.S. and should receive the endorsed instrument, which is treated like a check deposited to settle an account. So when you accept for value, you become the holder in due course of an instrument. You enforce the instrument on the issuer. He has a duty to pay if it is issued for value, but only if it is recognized and endorsed properly. See, to be a holder in due course, the holder must meet all of the elements in UCC 3-302. Let's look at it. UCC 3-302. Holder in due course. A. Subject to subsection C of this section and section 3-106, subsection D, holder in due course means the holder of an instrument if the instrument, when issued or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its anticipatency, and the holder took the instrument for value in good faith without notice that the instrument is overdue or has been dishonored, that there is an uncured default with respect to a permit of another instrument issue as part of the same series. D. Without notice that the instrument contains an unauthorized signature or has been altered. E. Without notice of any claim to the instrument described in section 3-306. And F. Without notice that any party has a defense or claim in recoupment described in section 3-305, subsection A. Do you understand? From UCC 3-303, official comment: if an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. Do you understand? Take that in inverse, right? If an instrument is issued for consideration, the issuer has no defense to the obligation to pay the instrument. Refusal for cause. In general, it is better to accept for value every instrument you get rather than refusing for any of them. Do you understand? For multiple reasons. Why? When you refuse for cause, you're refusing to take the instrument because of the defect in the instrument. This requires a larger knowledge based on statutes, codes, and so on and so forth. Not something most people want to learn, especially when you are a free man on the land. It also requires that the transferee addresses specific defects. So this will require you to be able to think on your feet in court. And this is a lot of trouble when you could just accept the value. When you accept the value, you are aiding your country by accepting all of their offers rather than refusing. You are aiding them in a time of emergency, bankruptcy, and reducing the national debt without recourse. Adding without recourse to a signature, my good brothers and sisters, is another qualified endorsement. It takes a signatory out of the equation. It removes all liability the endorser might have on the instrument. You are not the accommodating party or responsible party when you use this endorsement. So in general, when using the acceptor for value, it is better not to use this so that you could be seen as an aid to the U.S. You're agreeing to remain responsible in agreement, and you are seen as an ally. Suretyship. Your citizens are presumed to have agreed to be a surety for repayment of the national debt. Being a surety is better than being an accommodation party because the accommodation party gives its name and credit but gets nothing in return. A surety receives an asset for agreeing to be a surety. Let me give you an example of what I'm talking about. Suretyship is not always good though, but let me give you an example. An officer may need two sureties before he could actually commence his official duties. He will find two people who agreed to be as sureties. They would sign a document, perhaps a bond, right? As sureties for the officer. The officer would give the sureties an asset, like a deed of trust, as a security for them in the event that they would be required at some time to pay a debt for the officer. If the officer were a tax collector and he died, all of his accounts would have to be settled. If there was no money in his account to pay over the taxes he had collected, his personal property would be used to settle the debt. The U.S. and its creditors do not want to spend time or money to liquidate the dead officer's personal property, so they just go to the sureties to collect. The sureties require to pay immediately. So then the sureties, as holders in due course of the deed of trust, have the right to enforce the deed. You understand? They can call the real property connected to the deed of trust so they can reimburse, right? Dead officer's shares cannot claim a right to the property because the deed of trust the sureties hold is an enforceable instrument. See, from that perspective, sureties are good. So sureties for the United States have that same option. Since the sureties are fictions, the people who represent these sureties can opt to use their prepaid accounts to pay when they receive instruments that are issued and transferred for value. They do not have to pay with the public deeds, accounts, and cash of the persons that they represent. If they do pay with public currency, they have a right to be reimbursed if they opt to use their prepaid account by accepting it for value. They use the Secretary of Treasury to set off the debt. Either way, the surety stays in honor and performs according to his promise. Do you understand? Do you understand? So, summing it all up, folks, be sure to attend the webinar this weekend, this Saturday and Sunday, to learn more, much more. Completely comprehending the accepted for value. If you're in trouble with credit card debt, student loans, foreclosures, what have you, auto loans, be certain to attend this webinar and get your mind right. There's a trust created by the Constitution and one created by President Roosevelt in 1933 when the gold and silver was removed. The people are beneficiaries of these trusts if they correctly accept their birth certificates for value. And accepted for value is establishing your position as a holder in due course, the transferor, enforcer of the instrument, and the beneficiaries of the trust. Why would you not want this? Accepted for value is a qualified endorsement you gain as security entrants in the instruments. Instruments that are not backed by an intentional written promise to pay or perform must be issued for value. The issuer of an instrument holds the liability on the instrument. Instruments issued for value have no value until they are endorsed. An instrument is issued or transferred for value is for a promise of performance to the extent the promise has been performed. Do you understand? That's all I have for you for now. So go ahead and like the video, share the video, and be certain to attend the webinar this weekend. You can click the link below this video in the room, and I'll see you this weekend if you want to be debt free. For now, I'm going to say shalom, peace, till the dark is out.